All right, I think we've got everybody back. Madam Reporter, are you ready?
Yes, sir.
Okay, Madam Clerk, are we ready?
Yes, Your Honor.
Okay, thank you. We'll continue with the Mr. Pryor's examination of Dr. Davidson. I'll remind you, Dr. Davidson, you're still under oath. Mr. Pryor, you can continue your direct. You're on mute, Mr. Pryor.
Dr. Davidson, as part of your analysis and evaluation of this particular case, you prepared a report, is that correct?
Yes.
And that report is 24 pages, and it's been signed by you, and my understanding is it's been provided to the court by Mr. Means, provided to Mr. Wood, provided to me as well. Judge, at this time, I'm going to move for admission of Dr. Davidson's report as an exhibit.
First, we need to have it marked. That would be Exhibit 3, I believe.
Oh, I'm sorry, Judge. I thought it had already been marked. I apologize. So I have it down as exhibit number 4, but if the court wants to put that down as exhibit number 3, that's fine.
We can use whatever number you want, Mr. Pryor. I don't. We've had 1 and 2 admitted, so I was just.
Let's stick with this. The court suggested exhibit number 3 and have that marked as exhibit number 3, and then I move for admission of the exhibit.
All right. The report of Dr. Davidson, dated December 31st, is marked as Exhibit 3. Is there any objection to the admission of the report, Mr. Evans?
No, Your Honor.
Okay, then by the exhibit is admitted, exhibit number 3, and that is Dr. Davidson's report.
And may I proceed, Your Honor? Judge, may I proceed?
My apologies. Yes, you may, Mr. Pryor.
Thank you, Judge. Dr. Davidson, I can't have you look at your report while you're testifying, but at any time during this process that you feel that you need your recollection refreshed, I would ask you to pull out your report, review it, and then when you are done, set the report aside after your recollection has been refreshed, and then testify on that refreshed knowledge. I assume you've been through that before, but do you understand that, Dr. Davidson?
I do.
Okay. So, Dr. Davidson, I'm going to start at the beginning of your report, and that's on page 7 of the report. And Judge, the difficulty with this Zoom is, unfortunately, I may have education experience, 25 years of doing this, but technological experience is incredibly limited. So I don't know how I can get the report on the screen, but I will refer by a page number and paragraph, and I believe all the parties have that report, if that's acceptable to the court.
That would be fine with me. I do have a copy I can view here.
Okay. And Dr. Davidson, do you have a copy of your report with you?
I do.
Okay. And again, I do not want you to look at the report while you are testifying. If at some point you don't have a clear recollection of what you put in the report, advise me, and we'll go through the process of refreshing your recollection so that we follow the rules as they are set forth that we're guided by. Do you understand that?
I do.
Okay. So Dr. Davidson, on page 7 of your report, you started out with the first statement that Mr. Wood made on the recording. Everyone is kind of running down the kid's case because they were last seen in Rexburg and you were living in Rexburg, and then there's some narrative after that in your report. You made a conclusion based on that narrative where with the last statement being that we are going to be filing conspiracy to commit murder charges against both Chad and Lori. And what was that conclusion you made after listening to and reviewing that narrative?
It's going to be difficult to recall these pieces on such a micro level. Do you want to tell me a little bit more about the narrative, or?
Well, I would have you refer to page 7 of your report, Dr. Davidson.
Give me a second. Got it.
And if you would read the middle of your page of your report where it starts with Robert Wood being highlighted and read down to the words Garrett, okay.
Okay, so I don't have anything highlighted in my report, but are you talking about Robert Wood with Tylee was last seen? Or
Yes, and you made a conclusion at the end of your report. You made a conclusion with a check mark.
exactly.
So what I need you to do before you testify is review your recollection of that finding that you made, and then set the report aside and then testify.
What I'll do is I'll just make it as clear as I can. I'm doing a quick scan and here's my finding. And if that's inadequate or troublesome, any of you can let me know.
Okay.
So looking at that, scanning that information, the conclusion I had was that this would be a type of bias that I call inner circle bias.
Okay.
And inner circle bias is a situation where a witness is provided with information that's not known to the general public. And so it's an effort to include the witness in sort of the inner circle of information. And as a result, it can be co-opting of that person to really join whatever that inner circle is. So that would be the bias that I believe was active in that particular interchange.
And the interchange is where he talks about seeing the kids in Yellowstone, and then his decision of telling Miss Shiflet that he's going to file murder charges against Chad and Lori. Is that correct?
That's correct.
And co-opting, talk a little bit about the co-opting.
Co-opting is, it can be very, very obvious, or it can be very subtle. But co-opting is the manner in which you kind of pull a person into your viewpoint. So for example, just as a totally different example, because earlier I mentioned abuse, we could talk about how, say, everyone knows that people that abuse children really are pretty bad, right? And what you should know here is that we have information to that effect. So what I'm doing is I'm informing someone and also kind of setting the expectation that they would align with me in my group that would be opposed to whatever the other group does or is.
So when you're talking about groups, what you're in essence saying, and correct me if I'm wrong, Doctor, is that the statement by Mr. Means to express to a material witness that in the future these charges are going to be coming, it's his attempt to bring that witness to his side and basically push the other side, i.e. the defense, away. Is that fair?
Objection, Your Honor. Counsel's testifying.
Saying that objection, I think it also misstates you. Indicated Mr. Means had said that, so why don't you re-ask the question in a different way?
When you're talking about dividing the particular parties, the bias you're talking about is for the prosecuting attorney to bring him, or to bring Summer Shiflet into his side of the case. Is that fair?
Your Honor, again, counsel's testifying.
Okay.
This is a direct examination, not a cross.
What's the purpose of the bias?
Mr. Pryor, I'm not done with the objection ruling, so I am sustaining the objection.
Oh, I'm sorry.
Another question.
What is the purpose of in this particular case specifically, bringing a witness into the inner circle?
Well, I would have to speculate as to the purpose, because I don't know the prosecutor's purpose. I'm just identifying the nature of the bias that's involved, which is what I would call inner circle bias.
Okay. And is this inner circle bias, in your opinion, an attempt to influence a witness?
It could be construed that way. Again, I don't have the purposefulness behind it from, in this case, of the prosecutor, but whether it's intentional or unintentional, that bias can have easily that consequence. That's why it's called a bias.
Okay, so it's not a matter of whether there was an attempt to influence a witness, it's whether it was purposeful or unintentional. Is that fair?
I don't think I can speak to purpose. what I'm trying to say here is to back up earlier to my testimony. Best practices argues to minimize bias in any form because it can lead to intentionally or unintentionally manipulation, coercion, setting expectations for how somebody would testify and so forth. And so inner circle bias is going to be a type of bias that will try to, again, inadvertently or advertently, draw that person into the inner circle, align with the person's inner circle in their viewpoint and the scope of what they may speak about or testify to.
So I need a bit of a clarification. When you're talking about someone drawing someone into the inner circle, you're talking about the person who provides that information, and you are sending that message to someone to draw them into your inner circle.
Correct. It's initiated by the questioner or initiated by the person who is taking the lead in a meeting, and the effort is to draw them into that person's circle, not the witness's circle, but in this case, a prosecutorial circle.
So when Mr. Wood comments that he's going to bring these murder charges against Chad and Lori, it's your position that that could be construed as Mr. Wood trying to draw Summer Shiflet into his inner circle.
I would probably not necessarily say that with the example you gave. I would probably say that that would then become a statement that would likely very much alarm a witness and have them wondering, what do I do to avoid that potential charge?
So in other words, go ahead, I'm pleased.
Well, I don't think that would draw somebody into the inner circle of I'm advocating for a capital charge.
Okay.
I don't think that would be the impact of that particular statement.
Okay, so what you're suggesting, and please correct me if I'm wrong, is that that statement that statement would have the impact of causing the person, in this case Summer Shiflet, to offer information that would avoid that consequence.
That would be a good possible conclusion, yes.
Okay, all right. Let's move on to the next part where it starts with Garrett OK on your report on page 7. And if you would read down to the bottom of page 24, I would appreciate it to refresh your recollection.
Okay, let me look real quick. So it says Garrett OK, Robert Wood, and we're not shy about that. We've told both attorneys. His attorney keeps pretending like I've never said that. You want me to read it out loud like I'm doing?
By all means, if you want to, that's fine.
Okay. And it says what? But we have to. But I kind of want to give you a little bit of background of where we are and kind of our theory of how this ended up where it was. We know that this is not the same Lori everyone else knew. What's so strange to me is everyone we talked to who knew Lori before this, she was primary president. She made quilts for these kids. She made everything fun. Everyone loved her. She loved everyone.
Okay. And then you come up with some comment with a check mark. And if you would read that comment and then set it aside and tell me what your analysis is in that regard.
Well, to the bottom of 24, there's one comment, and then there's two more in the top of 25 that are related to that passage.
I wanted to do it one at a time just so we didn't become confused.
So at the bottom of 24 that says best practice mutual activity. The mutual activity of listening to this witness has yet to occur. The prosecution is actually testifying to the theory of the case, which risks influencing the witness narrative. No open-ended questions or active listening has occurred. The task of interviewing the witness is trumped by case information.
What do you mean by that then?
Well, what I mean is the stage is being set here for the prosecutor informing the witness of the purpose of this meeting. That we're not getting into questioning her or just welcoming her to the day of questioning later in the interview. What's happening here is the mutual activity. The reason we're here, if I start only with this piece, the reason we're here is to understand better my viewpoints as a prosecutor of the theory of the case and what I'm anticipating or expecting your reaction might be to that. So the mutual activity for a person who came in for an interview as a witness is quite different in this meeting. It's not a mutual activity as being interviewed as a witness. Mutual activity is to be informed of the theory of the case.
Okay. And then you go on the next page, which would be page 8 of your report, and you talk about bias. And would you review that provision and then be prepared to testify about what you mean by that?
Yes. Give me 1 second. Sure, I'm ready to go with that if you'd like.
Okay, let's talk about the bias and the derogation.
Well, the derogation comes with the extracurricular comment about the defense attorney. The defense attorney is not listening, for example. And so when you have a person who has great influence over the proceedings, the prosecutor in this case for the state, when they derogate the defense attorney, what's happening is really a not so subtle statement that this person should be really disregarded. This person is not a person who carries any real weight. They're just not thinking clearly. And the impact of that, if I'm a potential witness, now is to have to determine, well, whose side am I going to be on? And who do I really listen to? Since we've had clarity on things like death penalty, who do I really want to try to speak to? Because apparently the other person, the defense attorney for my sister, is simply not with the program.
Okay. And then you went on to talk about in-group versus out-group in your report. Explain that for me, would you please?
Right. Well, the in-group and the out-group, again, is, in this case, the prosecutor, in providing the theory of the case, is letting us know that his group is the in-group. This is why there is this education on his theory of the case. The out-group, with the incompetent or the clueless defense attorney, if you will, is the other group. And that happens to be the group that I mentioned before with derogation. So when you have an in-group, out-group bias, what you're really doing is you're laying the foundation or the seeds for a witness to be able to decide, who are you going to really align with? The problem is, if we go back to best practice, they shouldn't align with anybody. The focus should have been, what do you have to tell us that's reliable for this case and the information pertaining to the case? What's your information? Not what is your alignment.
Okay. In the next paragraph, it starts with Summer Shiflet saying, "Great mom." Mr. Wood makes a comment, and then you come to a conclusion as well. Would you take the opportunity to refresh your recollection on that paragraph, and then let me know when you're ready?
Okay, just a minute. Yeah, I'm ready.
Okay. So Summer Shiflet makes a comment that says, "Great mom." Mr. Wood makes some comments. If you would be so kind as to read Mr. Wood's comments.
Great mother, that's what everyone says, and you know. So one thing I'm going to ask of you to consider is maybe something happened. I don't know what. I don't know if it was psychological. I don't know. I don't know if we'll ever know. But something happened, and I think Colby, the way he said it to me, I think, is kind of the person who is in that jail cell is not my mom, it's someone else.
Okay. So you came to a determination, and there's a check mark in your report in the middle of page 8 that says bias. Would you explain your analysis?
Yes, confirmatory bias is what I noted, and confirmatory bias is when a person presents information selectively to confirm their viewpoint of something. And so in this particular case, the viewpoint that's being presented and confirmed is well, it looks like she's involved, but she's a different person. She's someone else. And so we have here an example of confirmatory bias where we have an evaluative statement about the defendant by the prosecutor to a witness before that witness has been interviewed. That's a problem.
Okay. Does that rise to the level of trying to influence a witness?
Well, again, that's going to be a matter of my determining purpose. But if I can slightly modify your question, I would say, can that lead to influencing a witness? Not, was that the purpose of it? Yes, it absolutely can lead to influencing a witness.
Okay.
It is not a best practice approach.
Okay, and is this ever an acceptable practice in interviewing a witness? This confirmatory questioning in this way?
I'm only smiling because in a bad read technique interrogation, the answer is yes, but this is neither in that situation at all. So the answer is no. This is not appropriate. You're trying to get untainted, raw information that's reliable from a witness about a case. This is not that example.
Okay, so this is actually an example of trying to taint the information you're getting from a witness. Is that right?
It would be an example of that, yes.
Of tainting a witness's testimony.
Correct.
Okay, let's move on where it says Summer Shiflet, yeah. And that's in the middle of page 8 of your report. If you would be so kind as to review the rest of page 8, and actually that would go through to the bottom of page 8 just before it says Summer Shiflet.
Okay, I'm ready.
Okay. Why don't you state what Mr. Wood said, and it starts with the flip side.
The flip side of that is, I shouldn't say the flip side, but I want to be clear. I'm not going to pull any punches on any defendant in this case, right? I've got my job to do. And Summer Shiflet says, absolutely. And Mr. Wood says, but we also want the truth and the whole truth and the context of it. And Chad Daybell is, did you ever meet Chad? And then at the bottom, Summer Shiflet of this page says, so I met him once at a preparing people. I went to one preparing people thing.
Okay. And then you, between the Summer Shiflet and Mr. Wood, you talked about acquiescence and bias. Would you elaborate on what your finding is in that regard?
Right. One method of bias, or one aspect of bias called acquiescence, is when you ask questions in such a way that you elicit confirming responses or negative responses from the person that you're talking to. So as an example of an acquiescence, it would be like, you met this person, correct? Yes. They aren't very nice, are they? No. So you would ask questions where this person's agreeing with the questioner. And that acquiescence, if it continues across an interview, really shows a shaping of the testimony or the nature of the reply from the interviewee, rather than an open-ended, neutral kind of investigation. So in this particular case, I'm saying that there's acquiescence because the first beginning of the pattern is she says absolutely.
Okay. So is this a situation again where the witness testimony may be manipulated or influenced by this acquiescence?
The nature of the questioning, if it's repetitive and leads to acquiescent responses, does shape the nature of that person's testimony.
Without a doubt?
Well, there's always doubt, but that's why we would use open-ended questions, because it doesn't demand a yes or a no or an absolutely or a never. It just requests a narrative. Here we have questions that are demanding a yes or a no, or the person's volunteering it, which goes back now to in-group and out-group kinds of bias, because they're confirming I'm in your group.
Okay. And by her comment, absolutely, and throughout this report, Ms. Shiflet is confirming that she's in Mr. Wood's group.
By the time you get done with the report, that's correct.
Okay. Now, you noted in your report on the last line of acquiescence bias that this pattern of witness acquiescence repeats throughout this interview. You saw other instances where Mr. Wood and Ms. Shiflet engaged in this bias acquiescence. Is that fair?
Yes, I literally went through and at one point actually counted the number of acquiescent responses. I don't recall a number, but yes.
And was it numerous?
It was almost 100%.
Okay. So then you went on to mutual activity best practices in your report. Would you explain that for me?
Yes. She's present voluntarily, in my understanding, to be interviewed. So we actually have an interview question, but it is a closed-end question rather than open-ended. Do you know Chad Daybell? Yes or no is the answer. And the activity then that begins to be defined is A, I want to educate you on the theory of my case, and B, if I'm going to proceed with questioning, they're going to be closed-end questions instead of open-ended questions.
And in this particular case, this wasn't so much a pattern of asking questions as it was a dissertation of his Mr. Wood's opinion of the case. Is that fair?
That's correct. There's literally, this is the only question that was asked.
Right. Okay. So let's move on with your report to page 9, if we could, sir.
Okay.
And if you would read the first part of page 9 and stop after your analysis where it says Summer Shiflet.
So you want me to read it out loud again, or just?
You don't have to read it out loud. If you want to read it to yourself, and then we can talk about it and do your analysis through each section.
I know it's in the record. Sure. Give me 1 second. Okay, I'm ready when you are.
Okay, so at the conclusion, Mr. Wood says, okay, of course he said that. And then you come back with your analysis in the report that says best practices, mutual activity. Would you explain your analysis in that particular part of the discussion?
Well, yes, it's defining what the mutual activity would be if we have questions, which is I ask you a closed-end question, you give me an answer, yes or no, or something similar. And by the way, you'll notice that there's no follow-up to it. So we have questioning here, which is not really eliciting a response about the witness's opinion on things. It's actually eliciting a response to the questioner's opinion on things. What do you agree or disagree with what I just said? Do you know or don't you know? And that, again, in terms of best practices or having an interview, is not a best practice. This taking place before the interview is also not a best practice, because it's really developing a mindset about what interviewing would look like. That's why I say we have a mutual activity problem.
And I want to elaborate on that a little bit. Quite honestly, when you say it's not a best practice, the interview, and you didn't go over the interview by the police with Summer Shiflet, but what you're suggesting, correct me if I'm wrong, I want a clarification, is that the discussion that Mr. Wood had with Summer Shiflet prior to the police is what you're referring to. Is that correct?
Yes.
And that discussion that Mr. Wood had with Summer Shiflet prior to the police is troublesome. Would you agree with that?
Well, that's my conclusion, yes.
Okay. And it's influential, is it not?
I believe, based on the responses that I saw in this particular 18 minutes, that yes, it was influential.
And it would have an impact on Summer Shiflet's testimony. Would you agree?
I think it likely would.
Okay. Let's move on with the rest of the report that we spoke of. And you talked about, after Mr. Wood said, okay, of course he said that, best practices, mutual activity again, or I'm sorry, bias, stereotyping. Would you discuss your analysis in that regard?
Well, this is stereotyping the other defendant, because the of course he said that really is a gratuitous statement that says, what would you expect from this person? So from that standpoint, I would say that it is a stereotypical comment, And much like we have the derogation earlier of the defense attorney for Ms. Vallow, here we have a stereotyping of the other defendant as a person who would, of course, say that. And in those regards, if I'm a witness hearing this, I am now getting taught how I should think about both of those people.
Okay, and then we move on, and there's a couple of statements, or a statement by Ms. Shiflet, Mr. Wood. In essence, the comment is, welcome to Chad Daybell, and you put down best practices, mutual activity. Explain that analysis.
Yes, it's really the same thing. The mutual activity is the purpose of our meeting. Our mutual activity here is to understand on the cast of characters and the theory of the case, who's bright, who's not bright, who's bad, who's not so bad. Who carries greater culpability, who really does not, who was a better person at one time, who was not. So we have here a shaping, if you will, of what people's roles are, and that's why I call this a mutual activity bias.
Okay, and this mutual activity bias could be understood to mean that you're trying to influence a witness again. Is that correct?
It could, yes.
Okay, let's go down to the next analysis, which is bias confirmatory at the bottom of page 9 of your report.
Okay. Well, the confirmatory bias that I'm referring to here comes from a statement that is an influencing statement. So what I want by the prosecutor is a statement. That leads to a person either ignoring the statement, denying the statement, or affirming the statement. And in this particular case, as I recall, she initially tends to deny it, but then with one or more comments from the prosecutor, she basically acquiesces.
Okay, so in other words, in your opinion, initially denying the statement, denying this, and then acquiesces, that means she changes her statement to the prosecutor after he prompts her with some narrative. Is that a fair analysis?
That's absolutely correct.
Okay, and that would be construed as coercing a witness. Is that fair?
If we can put that in context of coercion is on a spectrum. So it can be anywhere from a nudge to a push off of a bridge. And depending on what the prosecutor says here would be somewhere in that spectrum, if you wanted to look at it or not.
And in that spectrum, it still constitutes coercion of a witness, does it not?
Your Honor, objection asked and answered.
Same that objection, it was asked and answered.
I'm sorry, Judge, I didn't hear your response.
The objection sustained.
All right, I'll move on, Judge. That's okay. Then if you would be so kind, Dr. Davidson, to read the bottom of page 9 and the top of page 10 of your report, and then we'll get into the analysis of those statements as well.
Okay, got it.
Okay. If you would be so kind as to read Summer Shiflet's statements and then Mr. Wood and go through that so we have a context of what we're talking about.
Sure. On the bottom of page 9, Summer Shiflet, I have my own opinions for him, don't get me wrong. Robert Wood, I bet you do. He is highly manipulative. Summer Shiflet, yeah, he is. Robert Wood, I'm not going to say he's highly intelligent, but you don't have to be highly intelligent to be highly manipulative. Summer Shiflet, absolutely. Robert Wood, he is extremely manipulative, pardon me, and your sister manipulated him in some ways too, but the context for everything that happened came from Chad.
Okay, so your analysis starts with best practices, mutual activity. Would you explain that analysis?
Yes, again, as you can see as this unfolds, the nature of our purpose of being here together, the mutual activity, keeps getting refined and defined. And so in this case, when she says, I have my own opinions, he responds not in telling or asking, well, tell me about that. He responds, well, I bet you do. And so we really have here a statement that says, to me, I bet you do means I'm not really terribly interested in pursuing that. I told you what I was interested in pursuing in what I just said to you earlier here. And so that's the mutual activity that we're talking about, defining and refining the scope of what the purpose is.
Okay, and then bias confirmatory is your analysis based on what you previously read. Explain that to me, would you please?
Right. So what we have here are statements to the witness about the nature of Chad Daybell. He is not highly intelligent. He's manipulative. He's very manipulative. This really is something that all came from Chad. So we have a qualification. Some of it may be from Lori, but it all came from Chad. So we have a layout of statements that either can be confirmed or not be confirmed. And in this particular case, as you'll see in the narrative that developed, the next thing that occurs is she confirms that statement. So it's a confirmatory bias. This is what I believe. This is what I want to hear from you. Yes or no answer. You agree?
Okay. All right, and then let's move on to the middle of page 10, where it says absolutely, and then Mr. Wood, unfortunately, and if you would be so kind as to read those as well.
Summer Shiflet, absolutely, responding to what I just described were statements about Chad Daybell. And then Robert Wood, unfortunately, we have enough evidence to prosecute him, and we are. The case against your sister is stronger, but I kind of want to give you just that background. That's the kind of context that we see this guy. This guy came in here and, not making excuses for anyone, but kind of blew up this situation, and he did not care who died.
So you talk about mutual activity best practices.
Right.
What's going on there?
Well, what's happening is he's just further developing the narrative on his theory of the case. And in developing the theory of the case, depending on the response of the witness, Summer Shiflet, we're going to see whether or not she acquiesces, the impact that it has on what she has to say, and so forth. Again, we are miles apart from a meet and greet about, I'm glad to meet you. Here's the purpose today. You're going to be interviewed by, have a nice time in town. We have here a full-blown exhortation on a theory of the case with her sister and charging and so forth hanging in the balance.
Okay. And in your comments, you say that it is apparent the prosecutor is in control of the narrative and there is little interest in the witness information. Would you elaborate on that for me, please?
Well, yes. He's not asking for any information. And when there has been disagreements, like I mentioned before, I bet you have, or things to that nature, they're really just shut down. Here, we have a situation where he's laying out his narrative and not asking anything about her viewpoint, which she would testify to, and how she perceives things. It is his narrative that is controlling this conversation.
Okay. All right. And I would actually then ask you to start with the Summer Shiflet, and then you have best practices analysis. And if you would be so kind as to recite that narrative as well, so we know what we're referring to.
Summer Shiflet, responding to the previous narrative, says, Robert Wood continues, who got hurt? And that's an extension of a sentence. And he did not care who died, who got hurt. He did not care at all. And this is Robert Wood. And the other thing I can tell you is your sister truly believes that everything she's done has been done in righteousness. Summer Shiflet says, I know. Robert Wood says, I know I'm kind of using LDS speak. And then Garrett, an attorney, says, yeah. And then Summer Shiflet says, 100%. That's my interpretation also. I think she 100% believes.
Okay. The term LDS speak, the reference to LDS speak, what is the significance of that statement?
Well, it's an inclusionary statement about a person's religion. The Latter-day Saints of the Church of Jesus Christ, more colloquially known as the Mormons. It's a alert to the witness that I can speak this language. And it becomes apparent as the narrative unfolds that the witness is very religious and is oriented towards the LDS faith. And the prosecutor has alerted her to the fact that he is as well. He brought it up. She did not.
Okay. And what he's saying to her basically is, I speak the same LDS language you do. Is that fair?
Yes. And that somehow is relevant or should be relevant to the nature of our relationship.
Okay.
Otherwise, why would you bring it up?
Okay. And then you go down with your evaluation of best practices mutual activity. Would you elaborate on that?
Well, what's happening now is as we refine and define the purpose of our meeting, what we have is a religious component to it now. So not only am I looking to see if you'll confirm the theory of my case, but I want you to know that I have the same spiritual beliefs that you do, and that's going to potentially be relevant to how I interact with you, and maybe even relevant to how this case proceeds.
Okay. And then you talk about religious bias on page 11 of your report.
Right. So religious bias is when a person brings into play a factor. In this case, it's religion. It could be another group that somebody belonged to, and just have a slight change of what the bias would be. But when you have a religious bias, the purpose of the religious bias becomes, again, one of shaping potentially the testimony and the outlook of that particular witness, as well as including them now in the in-group. By the way, I also share your spiritual values. That's a new in-group. That's another in-group. And we have now language which, to a person who would not be oriented to the Christian world, we have the term righteousness. And so now we're beginning to speak about terms that are on a completely different planet than the legal issues involved. Okay.
And you put some comment in there about adhering to the tenets of her faith. What did you mean by that?
Well, this goes to an in-group, out-group issue. And the issue is, if somebody is a believer, a supporter of their faith, not a nominal believer where, yeah, of course I believe in X, Y, Z, but somebody who adheres to the tenets or the principles, the ground rules, if you will, and the beliefs that are codified for a religion. And the Latter-day Saints have highly codified beliefs, just like any major faith would have. So now when we have the tenet of faith coming into play, now we have a concern. For some reason, the LDS aspect has been brought up. Now, if I'm a witness, do I simply testify about what I have to say, or am I somehow supposed to conform any of what I say to my spiritual beliefs? This is a little confusing. Now, I'm not speaking for what Summer Shiflet thought, nor what Robert Wood intended, but I'm saying that would be the typical consequence. We bring up an extraneous piece of information that has strong principles attached to it that originally were not part of this discussion. We just wanted to know what you had to say about the case. Well, now when we bring up this extraneous information as a witness, what do I do with this? There seems to be an underlying expectation, and I had not anticipated this. Am I even more so in the in-group because we share the same faith? And what does that mean? Or what? That's how I would perceive this. And again, we have language like righteousness, which also tends to undergird the whole thing.
Okay. And if you would be so kind as to start with Robert Wood, she believes it, and recite that narrative, and we'll get to your analysis on that section of the recording.
Robert Wood, she believes it. Summer Shiflet, Robert Wood. Every once in a while, you'll see kind of a little crack in like a jail phone call. But, or she'll, and Summer Shiflet says, well, you've heard our conversations too, you know, that I get that she's not fully aware of what she's really done. And then we have Robert Wood. Right, yeah. And Summer Shiflet, I don't think she is. And then Robert Wood, yeah, I mean, well, I'm going to say this. I think she knows what she's done.
Okay, and then you come in with best practices and mutual activity. Explain your analysis there.
Well, what we have here is Summer Shiflet saying, I don't know if she's knows like, exactly what's gone on here. And the prosecutor is actually informing him not only of the theory of the case, but presumably of testimony that he'll be able to elicit that says she knows what she's done. In fact, she knows what she has done. And that when she says, I don't think she is, he's countering that. So again, we have the refining of the mutual activity group. What are we doing here? What's the purpose of today? And part of the message now becomes, well, if you want to be in my group, you need to know, I know that she knows what she's done. And I'm not interested in you going and saying to me, well, I'm not sure she does. Plus, we have revelation of information that I would presume is not publicly available as well.
Okay, so the read technique is a technique in which when you don't agree with what a witness is saying, you engage in this technique to influence the witness to change her thoughts on what she's suggesting. Is that fair?
That's one component of the read technique, and specifically the read technique basically is if you say something that is not in line with the theory of what we want to hear, we will interrupt you or we will counter what you have to say. We will not allow you to develop that train of thinking or that line of testimony. We will block it. And you see here subtle and not so subtle versions of that.
And in this particular case, do you have any doubt that this read technique was used by Mr. Wood in the paragraphs you just read?
I would have tremendous doubt that he used a read technique per se, because I don't see enough of a cohesive technique on anything here. I see more probably a personal style. I don't even know if he knows what the read technique is. I know he's a prosecutor, so I wouldn't be surprised. But the read technique is more oriented toward educating police detectives, police officers on interviews and interrogation. But the process of what you're seeing is consistent with aspects of a read technique.
So in other words, he may not be completely aware of what the read technique is, but he adopted that process in dealing with Summer Shiflet to change her testimony. Is that fair?
I'm not going to go to his purpose of trying to get her to change her testimony. I will go to agreeing that he's using aspects of the read technique, knowingly or unknowingly, that have the negative effect of biasing or eliminating and changing a witness's testimony.
Okay, so let's go on to the next part of page 11, where it says Summer Shiflet, and if you would read that.
Starting with, she knew enough to lie to us about it?
Yes.
Okay. She knew enough to lie to us about it. And then Robert Wood says, right, yeah, but the context under which it was done was this, religious. Not these ideas were out there. I can say this because I am LDS, no basis in the LDS faith. Just you said it in your phone calls to her. So anyway, that's kind of where we're at. And again, we're just really grateful for you coming in. And it's going to be hard to talk about these things. And Summer Shiflet says, oh, yeah.
So between Summer Shiflet and Robert Wood's statement, you put an analysis that says bias acquiescence. Would you elaborate on that analysis?
Well, the acquiescence is at the beginning of what I just read, and it's basically Summer Shiflet going, well, on balance, now that I've heard you, well, she knew enough to know something about what was going on. So she's agreeing with the narrative that's being presented by the prosecutor in that particular case, even though she initially is qualifying what she's saying, and that's rejected by the prosecutor.
Okay, so in your analysis where you say this illustrates prima facie influence of the witness, is that still your conclusion, that this is prima facie evidence of influencing of a witness?
Absolutely.
And that this witness testimony is now reflecting influence of the prosecutor rather than untainted narrative. Is that still your opinion?
It is.
I'll object to that. Counsel's testifying.
I'm not testifying, Judge. I'm reading what Dr. Davidson has in his report, and I'm asking whether it's still his opinion as an expert in this case that the testimony of Summer Shiflet has been tainted. That's all I'm asking. And if you want me to rephrase, I'll be glad to rephrase.
I would ask you to rephrase then, Mr.
Right. Based on the previous narrative that you read, was Summer Shiflet's testimony potentially tainted by this technique?
Yes.
All right. Let's move on to the rest of your analysis on page 12 of the report. And we'll refer to top of page 12 where it says bias similar to me. Could you offer your opinion on that, or offer your review of that particular provision?
Well, what I'm responding to here is the prosecutor's statements that what occurred is outside of LDS, I would presume outside of LDS teachings or practices in his narrative, and that what has taken place from a religious aspect is something that, as a person who's knowledgeable about LDS, is just outside their faith and outside of their beliefs. And so in this case, where we have similar to me, we have the witness having to make the decision, well, now who do I go with? I'm hearing not only that he's LDS, but he's also now speaking authoritatively about the LDS faith and its practices, and that this did not take place within those practices. So do I agree? Do I disagree? Why are we even talking about this? We have here a dimension that's been added that serves no other purpose except to either create some sort of bond with the prosecutor or to create some sort of bunny trail down a religious path in terms of what the testimony might be.
So in essence, influencing our testimony.
Potentially, yes.
Okay, let's start again with Summer Shiflet, the middle to top of page 24. And if you would go over that analysis after you've read Ms. Shiflet and Mr. Wood.
So I have, oh yeah, from Summer Shiflet, Robert Wood, we know that, and they're going to be nice, because obviously, you're not a person of interest. Keep going.
Oh, well, let's talk about the explanation and the best practices as in regards to the explanation.
Okay. Well, this is a part of the report that I think I made clear I don't have information on. Clearly, the recording started after some period of time, and whether that's 30 seconds or 10 minutes or an hour, I don't know how much took place prior to the narrative that I have in the transcript. So here, just in terms of explanation, in this 18 minutes, there is no explanation saying you are not a person of interest. What you have to say here, we're just looking at as a recipient witness. You're not under investigation for anything.
Okay. So I'm going to move around and move down to skipping your analysis on the middle of 24 and go to the Summer Shiflet. Okay, I'll do my best, I mean. And if you would start there.
Okay, and that's towards the bottom of 12.
Yes.
Summer Shiflet. Okay, I'll do my best, I mean. Robert Wood. It won't be easy. I know it's going to be a hard interview. Summer Shiflet. I was wondering if you would be willing to tell me, if you're able to tell me, if there's any progress in what you know about Tylee and her death. Is there any progress in her autopsy where you understand better? And then Robert Wood says, all I can tell. Well, Summer Shiflet says, I mean, do you have a cause yet, or is it close to one? And Robert Wood says, she is at the FBI state-of-the-art crime lab. Unfortunately, there's a lot of deceased bodies there that they're going through. Summer Shiflet says, I'm sure. And Robert Wood says, and so we're not. We don't know really any more yet. We may never know due to the destruction of that body. And yeah, we hope we'll find out. We may not, but obviously we know it's her. There was soft tissue that was still preserved enough to do DNA tests.
Okay. And what is your analysis of that provision?
Well, we have several things. We now have a sense from the witness that she's able to approach the prosecutor as part of the inner circle now, to ask the prosecutor information about the case. Now, again, we're now in a flipped position. Initially, apparently, she was in town to answer questions about her knowledge about anything relevant to the case. Instead, now the prosecutor is being questioned and being asked about knowledge about the death of the children. And the prosecutor gives her information. Again, I don't know if this information is in the public domain, but I doubt if it was at that point in time. And I'll take that back. That's just my speculation. All I know is he provides her with information that is investigatory. And as a witness, knowing that information prior to her providing answers to her interview, to me, is potentially highly prejudicial. It's going into an interview situation where now you've discovered potentially some additional information that may change your perception, your view, and even what you want to say because of what you've learned. So this is an example of really flagrant inner circle bias. The appropriate thing to have been done would be to say, I can't discuss this with you. It's an ongoing investigation.
Okay. And then if we could start with the middle of page 13 where it says Summer Shiflet and go through that narrative.
Summer Shiflet, yeah. Thanks that you guys found them like we wouldn't have ever known. Garrett, yeah. Summer Shiflet, and I would have never dreamed that she would ever hurt them so. Robert Wood, you know what? And everyone says that. Summer Shiflet, yeah. Robert Wood, that's what everyone says. Everyone says that I never would have. So it's a tragic thing. Summer Shiflet, it really is, yeah. Robert Wood, but I just want you to know how grateful we are. I know you don't have to talk to us. And so we're just grateful that you're willing to and helping us that way. And it's, I'm sure, kind of difficult knowing that they're asking for information that's going to help them in their case against your sister. But I guess the thing I want you to know is our whole goal is just justice for these kids.
And your analysis of that provision?
Well, offering thanks for coming, I think, is perfectly appropriate, and I have no problem with that. But the problem, and furthermore, saying that you may have a tough interview with the police and so forth, I mean, that's fine. Although I think it might actually increase somebody's anxiety more than empathy. But the concerning part about here is that all we want to do is we just want to have justice for the kids, is paired with they're going to be asking you for information to help in the case against your sister. So we have here an anchor point being tossed out there that says, look, we're looking for information to use against your sister. Again, if we go back to best practices, we're looking to get information, and then we're going to assess what that information does and says to us. And then we're going to determine what we're going to do with it. Not, we're going to tell you in advance. We're trying to get information against your sister. Hint, hint, you're in the inner circle. We're LDS here. You've already heard the theory of the case. You've already agreed to different things that I've said in terms of acquiescence. And so I do have a problem with that narrative, just very flagrantly setting the stage for the expectations of what would take place.
Okay. And then if we could go on and talk about the rest of the statements that are made on page 14 of the report, starting with Robert Wood.
Sure. It starts off at the top after the bottom of 13 where Summer Shiflet says, yeah, an acquiescence statement. Robert Wood, and our hope is it comes to it. Your sister's actually made some overtures. She might be willing to talk to us. Summer Shiflet, I hope she does. I pray for that all the time. Robert Wood, we hope she does. She actually was talking about with Chad about talking with us before we found the bodies, just a few days before, and he talked her out of it. Continue.
Well, what's the analysis in that provision?
Well, the analysis is a best practices deal where rather than try to get the witness's comments about her viewpoint on anything, he again is providing information about the case. And that information is going to do nothing helpful in the interview of the witness for her interview to be just a uncluttered, an unimpacted narrative of whatever she had to say to the police.
So in other words, your analysis is that the likelihood is that discussion with Ms. Shiflet is going to have an impact on Summer Shiflet's testimony with the police.
I think it's very likely. That is a strong concern.
Okay. And when you say a strong concern, would you elaborate a little bit on that for me, please?
Well, it's a concern that she's hearing repeatedly expectations about how this case is going to unfold. She's getting questions answered and given information that is not privy to the general public. It is a concern because that information is going to be in her head when she is asked investigatory questions by the police following this 18 minutes and whatever preceded it. We don't have a situation that really is a level playing field with a sterile set of questions being asked. We have preceding questions and instruction that is going to potentially and likely affect her responding.
Okay, and when you talk about a level playing field, what you're talking about is two sides of a particular case, i.e. the defense and the prosecution having a fair opportunity with a witness. Is that what you're referring to?
Your Honor, I'll object. Counsel's testifying.
I'll withdraw that, Judge, and I'll move on. Would you then go with Summer Shiflet at the top of the middle to top of page 14 and review the statements in that going through and through page 15?
All right.
Summer Shiflet, sorry.
Here, before I have you just read that in, we've already got in the record the transcript. We've heard the call as well. It's also in your report. So this is very cumulative to just read it verbatim into the record. If you want to review those, I will review them as well and listen to the analysis. If there's something in particular you think should be highlighted, Mr. Pryor, we can do that. But I don't think it's necessary to just verbatim read this transcript again when it's already been submitted in the hearing.
Okay, well, I guess I wanted to put some perspective on exactly what the analysis is with regards to each provision. And I guess my thought process, Judge, was simply without knowing what provisions we were talking about, it's difficult for Dr. Davidson to offer his analysis on each of the provisions. But if
I understand that, and I can read it. It's here before me also. I'm just trying to save my court reporter some brief getting through this hearing too, when we already do have the very record of what's being read.
Well, Judge, I mean, at this time, if you would like to take a lunch recess, I'll defer to the court's wisdom, or if you would like me to go on, I'll try to move through this much quicker.
Well, I thought maybe we could get through your direct with Mr. Davidson and then take a break before we go to the cross-examination. So if you want to continue plowing along, we'll do that for now.
Okay.
Thank you.
So Dr. Davidson, proceeding or starting on page 14 through 15, there's some discussion between Mr. Wood and Summer Shiflet, and you put in a reference saying bias acquiescence. Given the fact that the court would prefer not to have each of the provisions read, can you give me in some detail what you mean by that bias acquiescence on page 15 of your report?
Yes, and I'm just glancing at that section really quickly.
Okay.
Well, basically, there's a narrative here that takes place with the prosecutor. And in the narrative, Summer Shiflet agrees with the comments that the prosecutor makes. So she's not being questioned, she's being talked to and informed. And the acquiescence is she's just now agreeing again, basically with everything that is being said. So the acquiescence is an indication that a person is on board, that they are now in the in-group, that they have decided where they're going to cast their allegiance by and large. And that is potentially an indicator of testimony later that will be influenced.
Okay, now on the bottom of page 14, there's a provision, and it's 5 comments down, and it starts with Mr. Wood. Well, do you see that comment in your report?
I do.
Would you read that for me really quickly?
Robert Wood. Well, I'm the visionary guy, so you know, So anyway, again, I just wanted to meet with you real quick and introduce myself and Mackenzie Shees.
Okay. Now, his comment that I just wanted to meet with you really quick. In your opinion, is an 18 to 20 minute narrative a real quick meeting?
I think it depends on what the content would be. I could conceive of it as a quick meeting if it was a meet and greet without getting into the theory of the case and so forth. But I would think typically, because the day is set out for an interview by the police and presumably they're waiting or there's an appointment time, 5, 6, 7, 8 minutes. Glad to meet you. Glad you're in town. Hope things go well today. Just wanted to introduce myself. Would be more than enough time.
Okay. And then if you would be so kind, in the middle of page 15, review the statements that were made on the tape, and then let me know when you're ready.
Are you referring
Just
to?
not read them out loud. Just review them quietly to yourself.
I understand, but are you referring to the top of 15 to the
middle of 15? The middle of 15.
Down. Got it. Thank you. Okay.
Okay. Now, in the middle of 15, there's some reference by Mr. Wood suggesting that Mr. Means is incompetent and that he doesn't know what he's doing. You have analysis at the bottom of your report on page 15 that says bias derogation. Would you please elaborate on that for me?
Well, sure. In this particular case, there's really no purpose and no reason, if we're trying to get the witness's testimony, to have any discussion about any of the other attorneys or parties or players in this case. And so in this case, where the defense attorney is mentioned as incompetent, no experience, lying about the prosecutor, and that he basically will be recused from being a defense attorney when additional charges are filed, all really derogate both his reputation as well as his influence. Because he's inevitably going to be discharged, his influence is ultimately zero. He doesn't know what he's doing, so actually his influence could be negative. And furthermore, he's just a liar. So when we have all of this information, as in terms of derogation, in terms of influencing a witness, first of all, it'd be very daunting to challenge somebody who is saying this about opposing counsel. It would take a pretty gutsy witness to go like, well, hey, wait just a doggone minute. I don't think that's fair or that's accurate, especially when we know the stakes that are involved in this particular case. And so the derogation really serves a function to minimize the credibility, in my opinion, of the defense, and to further solidify, you're in my group, you're in the in group, we are LDS. I've told you information about the case. You know more than the average person. By the way, we don't want to go any farther than this. We have to, and it's really Chad. She knows, but it's mostly him. We have here, a continued pattern that's expanded now very flagrantly with the comments about the defense attorney. Okay,
and this is a flagrant display, is it not?
I've done this for years. I've never seen anything like this.
Okay. If you would go on with your review of the top of page 16, I believe there's 3 sections that I'd like you to review, and then describe your analysis of the inner circle bias that you relayed in your report, sir.
Right. So he's thanking the witness for coming in, which is fine, but the witness is then saying how weird this is to be speaking for the prosecution and speaking for the defense, and how she's torn. And that's a relevant comment to me, because the issue wouldn't be at all how she's torn. The issue should be, what evidence does she have to offer through testimony? That she may be torn is something that people could always discuss, I suppose, at a different point in time. But for her to bring it up is suggesting to me this conversation has prompted and promoted her feeling torn. She came in and has made some positive statements about her sister earlier in the narrative that were not followed up on or regarded. And now she's pointing out, I'm between a rock and a hard place. I'm on the horns of a dilemma. It's weird to be dealing with both sides in this. So the inner circle bias that comes out of this is, where are you going to land? How are you going to reconcile that? Whose side ultimately are you going to likely be on? Again, if this is an interview situation, ultimately, that's the reason she's here. There shouldn't be a side to land on at all. There should simply be her unfettered testimony.
Okay, so your comment, the prosecutor's statement, an effort to influence the witness, has caused cognitive dissonance. Please explain to me what you meant by that statement in your report of these statements that Mr. Wood had made.
Right. Cognitive dissonance is just a $5 way of trying to say, I'm feeling pressure on two different dimensions that are really causing me to struggle. And that's what she points out. Prosecutor, defense. Where do I go with this? The dissonance is the confusion that stirs up mentally. What should I do with this? How do I reconcile this? How do I handle this? If I'm asked a question and it draws on me to be loyal to my sister or to her defense, what do I do, having heard the theory of the case and the prospects and the information from the prosecutor? There's no reason a witness whose information is simply trying to be garnered should ever be put in the position of having to have that kind of internal battle. They should just be asked, what do they have to say? Not what do they have to decide to impact what they may say.
Okay. If you would be so kind as to read the rest of the narrative on page 16, and then discuss your findings on the top of page 17. And you could read it to yourself.
I am. Okay, so I'm ready.
And if you would provide us with some interpretation of your analysis in regards to the statements on page 16.
Well, what's happening here is, speaking just a moment ago about cognitive dissonance or being on the horns of a dilemma, prosecutor versus defense, she elaborates on that a little bit for a few lines. But then she now is comfortable enough to ask about whether or not there's going to have placed on the table the death penalty. Is this going to be a case where that will be something that will be thought, I believe. Let me check real quick. Yeah, so she asked whether there's going to be the death penalty, a capital charge. And again, that's reflecting she is extremely comfortable now with being in the inner circle of the prosecutor, because she's asking the person who's going to be responsible for making that capital charge if it does come about. And as far as being on the horns of a dilemma, we see a conversation about that. And we also would have to understand, this is my sister. Now, what do I do? How do I handle this being, and you take all the preceding information, being LDS, being this, being that, what do I do in trying to reconcile this? And how will this affect what I have to say when I am interrogated later today? Questions.
Okay. And then if you would be so kind as to review page 17 and then offer your evaluate or your findings on the top of page 18.
All right, so what we have here is a couple of biases that are concerns. One is the mutual activity, again, the refinement and the defining of what that means as our purpose. The purpose has been expanded by the witness who's comfortable enough to ask about the death penalty, but she gets a response instead of, that's something I can't discuss. or we'll have to determine that later. So she does get a response, and she's informed that that's something that he really doesn't want to do, and alludes to how if there was really the ability to have perhaps a plea deal, in a capital case in general, that would be life without parole. There's an allusion to that. So now we have the witness who actually has a little bit of power. What can she potentially do to influence her sister if she talks to her on the phone? Because about this potential capital charge, he doesn't want to do it, but and so we have insight into something that typically you wouldn't hear outside the prosecutor's office. They're charging decisions and they're charging contemplation. So that's a mutual activity issue, defining that our mutual activity apparently is to not just have you tell us what you know as a witness, but now we can go to the extent of determining what do you know about how they died? Are you going to bring up the death penalty for capital charges? This has become a very, very odd meet and greet prior to being interviewed. And then there's the inner circle bias, because she is a member of the in-group. She can go ahead and ask these really high value questions. Are you going to charge my sister with capital murder?
Okay, now you made some reference in your report on page 16, and I'll go back to that ever so briefly. And you said that, well, I may have that incorrect. In your report, you had referenced the fact that she now becomes a member of Mr. Wood's inner circle. Is that your assessment of what the provisions were referring to?
Right. That's part of what I just mentioned as being part of the inner circle. Now we really see pretty strong evidence that she has adopted that viewpoint. She is part of the inner circle. She's asking case-specific information, including charging information, and she's getting answers.
So specifically what you're saying, and please correct me if I'm wrong, at this point, this witness has adopted the prosecutor's theory of this case.
I don't know to what extent, but she is acquiescing to what he has to say. She's comfortable enough as part of the in-group to ask these kinds of questions. It certainly would appear to me that she is influenced strongly by the information she's heard and the questions she's been asked.
Well, let's go on to read to yourself page 18. Actually, you know what? I think, yes, let's read page 18, and then we'll talk about your findings on the top of page 19 when you're ready.
Okay, give me a second. Okay, I'm ready.
Go ahead.
We have a bias about religion because it's being said to her very clearly that, he's the one that really is the religious influencer in all of this, as well as how his views on theology and Latter-day Saint beliefs manipulated Miss Vallow. So we have a shifting of responsibility to Chad Daybell, part of the theory of the case, maybe a sigh of relief to the sister in her testimony. And from that standpoint, the religious aspect becomes a piece of the overall judicial picture, where it doesn't make any sense to have it be a piece at all. And certainly doesn't make any sense, and this is the next bias in terms of inner circle, to have the prosecutor pass on further his theory of the case that the main culprit in this is Chad Daybell, and it came about partly because of religious reasons and so forth. So we're way beyond, again, just you're in town for an interview.
Okay. And then what you did is you made a number of findings, and I'm not going to have you go over those. The report speaks for itself about those particular findings. What I do want to do is go to your conclusion page on page 22.
Okay.
Let's start with acting ethically, the American Bar Association.
Well, there's going to be model rules of professional conduct for the ABA, and I simply noted in my report, I'm not an attorney, I'm an associate member for what it's worth, but I have no basis to make any comments about prosecutorial conduct related to the ABA model rules of professional conduct. It's outside the scope of my capability.
Okay, acting with integrity, and you're talking about Idaho Criminal Code 182604 sub 3, which is talking about it's a crime to influence or coerce a witness. What did you include that in your report for?
Well, I included that because the efforts in this 18 minutes, to me, adversely affect the concept of free, full, and truthful testimony. Now, maybe not truthful, but certainly free and full. And so I'm simply suggesting, from my opinion as a forensic psychologist, that there was improper influence of the witness in this case by the prosecutor.
So your comment under acting with integrity on page 22 of the 24-page report is that the efforts of the prosecutor in the interview that I analyzed suggested improper influence of the witness. Is that still your finding?
Yes.
Okay. Avoiding, the next section is avoiding inappropriate interviewer behavior. Would you provide us your analysis on that conclusion?
Let me glance real quick. Sure. So here, very straightforwardly, greeting a person, asking open-ended questions and so forth. In terms of interview behavior, we really don't have an interview. It's a simple process. We don't have anything asked beyond one question about Chad Daybell. So the efforts that I see in this narrative have nothing to do with an interview of a witness brought into town to be interviewed. They have to do with influencing that witness, period.
Okay. And then I want to go down to the middle of page 23 of your report, where it says the witness is a vulnerable witness, and then provide your analysis of that provision.
Okay. Well, the witness is a vulnerable witness because of her relationship to the defendant. She's her sister. And to that end, anyone would acknowledge that that's an emotional relationship of one dimension or another, to the point that she has asked the prosecutor about whether or not capital charges will be brought. So a vulnerable witness, a person who emotionally is highly involved in a situation, is a person that really needs to have the utmost professionalism in their questioning and in their treatment and in their handling. And the reason is because their vulnerability makes them more susceptible than the average person to having their comments be suppressed, influenced, be exaggerated. You can go in whatever direction. It's going to vary according to the person. But that's why I raised a concern about her as a vulnerable witness, because I believe she is one.
Okay, and then the next paragraph, the interview with the prosecutor provides the witness, and if you would elaborate on that conclusion.
Well, I think that the thing here we have is really kind of fencing in the witness in terms of what's okay to believe and who she should align with and what's not. So we have it be known that the defendant's manipulative, he's wimpy, he's outside of LDS doctrine. He is a person that probably is the main bad actor in all of this, which may or may not influence what she would say about her sister, but you would think that it would, because if he's really the bad actor, then you don't have much to lose by saying whatever you care to about this sister, especially since the prosecutor does not want to bring capital charges and would prefer to have this case be somehow settled, perhaps. And then we have from there the defense attorney's malignment, really, again, putting a fence in, going like, hey, whatever's going on that side, it's not going to last, not going to be there. He's lying. He's incompetent. So don't pay any attention to that. I've answered your questions. I have cooperated with you. I told you what's going on. I'm your ticket.
Okay, and then the next paragraph says the prosecutor specifically asked the witness to consider various aspects. And if you would elaborate on your conclusion in that paragraph.
Well, in various times, I want you to consider, I want you to suggest, thinking about, I'm paraphrasing a little bit liberally here, but she is really asked to consider and told the theory of the case. And so when that occurs, it basically, in my world, in forensic psychology, you consider that coaching. I'm going to tell you what I think is accurate. You're agreeing with me. I have acquiescence. Let's keep going. Well, I answer your question. Now you're in the in group. So the impact of all of this is to, again, go back to the concept of co-opting. We're bringing that person into the circle. And now that person is highly vulnerable to providing information that will be favorable to the prosecution and not to the defense, in the sense that it may not be brought up, it may not be answered fully, it may be suppressed, who knows. But the impact of all of this is not neutral, and it certainly is not favorable to the defense. It is adverse to any defense, and it is favorable to the prosecutorial position.
Okay, and if you would be so kind, and this will be my last question, would you read the last paragraph of your report for me, sir?
It strains credulity to think that the efforts of the prosecution had no impact on the subsequent testimony of the witness. It is apparent during the interview that she seeks to please the prosecutor with her responses and begins to volunteer information in an apparent effort to help him. It is likely that the subsequent interview of the witness has been influenced and tainted by the nature of the initial interview with the prosecutor.
So is it your position then that this witness has been influenced by Mr. Wood's conduct during that 18-minute discussion?
It is.
All right, Judge, I have no further questions.
Prior, well, let's take our lunch break at this time. We are starting late, but we'll do a 1-hour lunch break. So we will be back on the record at 1:40 p.m. Does that give everyone sufficient time to do what they need to do during the break?
Yes, Your Honor.
Yes.
All right, thanks. We'll see y'all back in an hour. Mr. Davidson will continue with your testimony after that. Thank you. Or Dr. Davidson, I should say.
Thank you, Your Honor.